Good morning. I will call to order the June 30th meeting of the State Rules and Reg Board. Got an echo. We'll hold on just a second. Okay. I will start. Senator Warren is in the room with me. Representative Wassinger.
I'm here.
Great. Senator Billinger.
Now he's in the middle of harvest and says that he does not get good reception out in the field.
Okay.
So what I was going to try to do is call him and see if he could listen to it while by phone. I don't know if that will work.
Okay. And do we have Senator Falscadeau?
Yes, I'm present.
Good morning.
Good morning.
And Mary, have you been able to get audio? Okay, well, we will go ahead and get started. First of all, Happy New Year's Eve. Thank you all for being here on the eve of the fiscal year. Exciting day for everyone in accounting. And we will have some temporary regulations in front of us today that would be in effect at the beginning of the new fiscal year. But first, I will entertain a motion to approve the May 26, 2022 meeting minutes.
So moved.
Do we have a second?
Senator Falscadeau, I second.
Thank you. We have a motion and a second. Any discussion on the minutes? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Motion carries. The first set of temporary regulations on the agenda are from the State Board of Nursing, and I believe we have Carol Moreland here with us this morning. Welcome to the board.
Can you hear me okay? Everybody hear me? Okay. Okay. I'm Carol Moreland. I'm the Executive Administrator for the Kansas Board of Nursing. Good morning, and thank you for allowing me to come today. What I have to discuss with you today is temporary revisions to 7 of our regulations that deal with the licensure of advanced practice registered nurses and the practice of APRNs in Kansas. The temporary regs are to 60-11-101, 60-11-103, 60-11-104, 60-11-104A, 60-11-105, 60-11-107, and 60-11-113. These changes are in response to Senate Sub for House Bill 2279 that passed this session. We developed these in consultation with our general counsel. So what I will do is just briefly overview the changes in each of them. I don't know if you want me to stop after the first one or just keep going, or.
Why don't you go ahead, but if somebody has questions, please feel free to let me know and I will take questions.
Madam Chair, Senator Falscadeau.
Yes. Go ahead,
yes.
Senator.
So she referenced a bill legislation that passed. What's that bill number again, please?
It is Senate Sub for House Bill 2279.
Okay, thank you.
You're welcome. Okay, the first one is 60-11-101. The changes that we made to this is we struck out limitations and restrictions. And what the bill did is basically make it so that there are no longer restrictions and limitations for the APRNs as far as needing a collaborative agreement with a responsible physician. So you will see a lot of changes made throughout these regulations are because of that. So we struck the words limitation and restrictions. We struck out needing a collaborative practice, authorization, and also it no longer needs the presence of a physician. Not that it needed that before, but we went ahead and struck that. We deleted the terms authorization for collaborative practice, the definition of that, definition of physician, definition of prescription, and definition of prescription order. And on all of these, we added the language that the regulation shall become effective on July 1st of 2022. That is the first implementation date in that bill. There's actually two implementation dates. Part of it is July 1st of 2022, and then the national certification is July 1st of 2023. So going on to 60-11-103, this has to do with licensure and education requirements for the advanced practice registered nurse. So we added the part in here out of the bill that they have to submit proof of their APRN certification in their specific role and population focus that's granted by a national certifying organization that is recognized by the board and whose certification standards are approved by the board as equal or greater than the corresponding standards that have been established by the board for initial licensure applications. And this will start on July 1st of 2023. We also added the part that they have to submit proof of malpractice insurance coverage if the applicant renders professional clinical services as an APRN, unless the APRN meets one of the exceptions listed in the bill. There's 3 exceptions listed in the bill. And we were advised not to put those exceptions in here since they are listed in the bill. Again, the language that'll become effective on July 1st. 60-11-104 has to do with functions.
Madam Chair, are we taking questions along the way?
If you have one, certainly. Senator Warren.
May I? Thank you. Going back for just a second to 60-11-101, I noticed that the definition in subsection B, D, and E of prescription and prescription order were struck. Are those, I guess the first question would be the why, and the second would be, are those defined elsewhere in the Act?
We actually had these in the first go through for the approval. And we were advised when the review was done from the Attorney General's office to strike those out. They were not needed in here.
Thank you.
(60-11-104) functions of the advanced practice registered nurse in the role of nurse practitioner. There's 4 roles of APRN: nurse practitioner, clinical nurse specialist, nurse midwife, and the nurse anesthesia. So the first one is nurse practitioner. What we did here is strike out the term in B, based on authorization for collaborative practice, again, for the rationale that I explained. And we just added the language about being effective July 1st. 60-11-104A, this was the protocol requirements. The title was changed to prescription orders. This one, we struck out the language about a written protocol because they no longer need that. We added the language out of the bill, what they can do as far as prescription. Any advanced practice registered nurse may perform the following: prescribe durable medical equipment, prescribe, procure, and administer any drug consistent with the licensee's specific role and population focus, except any drug that's intended to cause an abortion. And 3, prescribe, procure, and administer any drug that is a controlled substance in accordance with the Uniform Controlled Substance Act as specified in KSA 65-4101 and amendments. So then we struck out the part of they need the information from the responsible physician because they'll no longer need that. And I believe that was most of the changes in there, other than the language that it would become effective on July 1st. 60-11-105. This has functions of the advanced practice registered nurse in the role of nurse midwife. You're going to see very much the very same changes that we made in the one with nurse practitioner. We struck out based on authorization for collaborative practice and added the language, this regulation becomes effective on July 1st. And then 60-11-107 is very similar, except it talks about the functions of the advanced practice registered nurse in the role of clinical nurse specialist. Again, we struck out the language based on authorization for collaborative practice and added the language, it will become effective on July 1st. 60-11-113 has to do with licensure renewal of APRNs. The changes here are actually on page 2. Because in the bill, it says any APRN whose initial licensure is before July 1st of 2023 may submit evidence of APRN certification to the board upon licensure renewal. And then the next one is the APRN shall provide proof of malpractice insurance coverage when renewing the license if the APRN renders professional clinical services unless the APRN meets one of the exemptions listed in KSA 65-1130 as amended by 2022 Senate Sub for House Bill 2279. And then just the language about it will become effective on July 1st of 2022. So the changes that we made to all of these are just in response to the bill. And again, these were made in consultation with our general counsel. We do have some permanent ones that I believe today the public hearing was published in the Kansas Register, and that hearing will be on September 6th. Any questions?
Thank you. Are there any questions from the members of the board? Senator Warren.
Thank you. Regarding 60-11-104A sub A2, were there any other stakeholders consulted with the change in the language in that subsection, or did that come exactly out of Senate Sub for House Bill 2279?
It's exactly out of there.
Out of the enacting statute. Okay, great. Thank you.
Are there any other questions? I have a few, but I'll turn to the other board members first. I can't see them.
I have a quick question.
Thank you. Representative Wassinger, go ahead, please.
Does this complete the nurse midwife regulations that we talked about at the last legislative joint rules and regs meeting?
No, it does not. These are actually separate because that's the certified nurse midwife independent that is actually licensed out of the Board of Healing Arts. And that bill that was passed several years ago, the regulation changes start with the Board of Healing Arts and the council. And once they have approved them, then they come to the Board of Nursing. The Board of Nursing approves them. Then they go back to the Board of Healing Arts. I will tell you, we just had a board meeting. The Board of Nursing just had a board meeting yesterday, and they did approve 2 of those. So there's 2 more approved. But no, this is not the same as that.
So if you have 2 more approved, how many more do you have to go? Can you give me an idea of that? I know that we asked you to get done within the next within 6 months, so I'm just curious where you are on that.
Right. Courtney talked about this yesterday. I'm trying to remember. I would say roughly 4 to 5, but I think there's 3 that the Board of Healing Arts is going to be bringing to the Joint Committee, perhaps. But Courtney has done a really good job of doing kind of a status update progress on them. So I think we're getting very close. Our intent is to have them all through within that 6-month period.
Thank you. I appreciate it.
I just want to confirm that Mary Greb Hall is on the line. Is that correct? Is she muted on our end or is she muted on her end? And also, Senator Billinger, are you with us? Okay, Mary can hear, but Mary, can you speak to us so that we can record a vote if and when one comes?
Madam Chair, yes, I've been unmuting to respond to you. So are you able to hear me?
We can now. Thank you very much. Are there any other questions from the members who are on the remotely at this point? Okay, I just have a couple. You talked about 2 different implementation dates in the statute. So can you talk to us a little bit about the need for these to be temporary regulations to go through a different process than the standard publication of regs?
Sure. The first implementation date is July 1st of 2022. That is removes the need for a collaborative agreement, and it also adds the requirement for malpractice insurance, and that they have to submit proof of that at the time of licensure renewal. So that is July 1st of 2022. The July 1st of 2023 is the national certification, the need to have that for initial licensure in their role and their population focus. I believe that one date was pushed out so that would give people time to get that, because that is a process that takes a little while. It doesn't just happen overnight. So I believe that was the rationale for the 2 different timelines.
Okay, and then can you address the need for them to be adopted, all the whole package to be adopted as temporary regs?
We just kind of did them at the same time. I mean, I guess the certification could be pulled out. It is part of the permanent. So we could certainly do that. They kind of mirrored each other, except we added the language about effective July 1st, 2022 to the temp ones.
Okay, thank you. And I'm going to ask one more question that's sort of preemptive because I've seen some testimony that might be coming. And so I understand that 60-11-104A addresses the statutory change for prescribing authority, and 60-11-104 is collaborative agreements for other processes. So could you address that for us? Because I think that it will come up in just a few moments.
Sure. Well, yeah, I have no doubt. Yeah. The legal interpretation that we got from our general counsel is it eliminated the need for collaborative agreement. In listening to discussion in both of the chambers, that was also a lot of the discussion too. So that's why you have it in front of you.
Thank you. Are there any other further questions?
Yes, Madam Chair.
Senator Falscadeau, please.
Yes, good morning again. Just for clarification, did I understand that they would have to, they would be required to have that licensure twice? You mentioned one effective July 1st, 2022, and then the other one in 2023. Clarify that for me, please.
Sure.
Thank you.
No, it's not actually a different licensure. What they have to get effective July 1st of 2023 is the national certification. National certification is an addition to licensure. We have never required it prior to this, but there would be a requirement now for anybody who's initially licensed with us starting July 1st of 2023, that they would have to submit proof of that. And then they can submit proof at the time of licensure renewal. Actually, a lot of employers have already required this, so it's not totally new to APRNs. They are very familiar with this national certification.
Okay, thank you. Thank you, Madam Chair.
Thank you. Senator Warren.
Thank you, Madam Chair. Where in Senate Sub for House Bill 2279 does it refer to the no longer needing a collaborative agreement that would take effect on July 1st, 2022? I know that the bill does say that it shall take effect and be enforced from and after its publication in the statute book, but I'm wondering, I'm just flipping through, if you could refer specifically to where the July 1st, 2022 date is for that particular part of the rules and regs that we're looking at.
How we were told, again, is that it would become effective on July 1st of 2022. I'm trying to think.
If I may, Senator Moore, that may be from the publication in the statute book, which goes to the July 1st.
That's what I'm thinking. It's the very last section of the 15 pages. Yes, that's section 5 of Senate Sub for House Bill 2279. So it's
the interpretation was everything would take effect on July 1st of 2022, except the sections that said July 1st of 2023.
Right, because the legislature had specifically said it's going to be July 1 of 2023, knowing that the publication of the statute book would be July 1 of 2022. So, well, thank you for clarifying that for those who are following along and listening. Thank you.
Thank you. Are there any other questions? Okay, thank you very much. Committee, I have Rochelle Colombo with the Kansas Medical Society who would like to offer some testimony this morning. Are both you and Ms. Wahlberg offering testimony today? Yes. Okay, great. Thank you.
Good morning.
And I guess I picked you first, but if it matters, you can.
Well, thank you,
Okay.
Madam Chair and members of the committee. I am Rochelle Colombo. I'm the Executive Director of the Kansas Medical Society, and I'm really just here to provide introduction to Catherine Wahlberg, who is our legal counsel, and to thank you all for the opportunity to provide public comment. We became aware these regs were made public 10 days ago, and we do understand that House Bill 2279 passed the legislature and that it was to go into effect upon publication in the statute book. Our comments today are simply reflecting our concerns that some of the proposed regulations go beyond what is authorized by House Bill 2279, which eliminated the written prescribing protocol. And so that is what we've brought Catherine Wahlberg here to discuss today. And I would be happy to answer any questions, but I'm going to defer to those specific concerns on the couple of regulations that we believe exceed the authority in the law to Catherine, if I might.
Certainly. Ms. Wahlberg.
Thank you, Madam Chair, and thank you, members of the board, for allowing me to speak today on behalf of the Kansas Medical Society. We are here.
Introduce yourself.
Oh, pardon me. So it's Catherine Wahlberg, and I am legal counsel for the Kansas Medical Society, and I'm here to speak on their behalf. So the Kansas Medical Society, as Ms. Colombo said, is not here to dispute the validity of the law that was passed pursuant to Senate substitute for House Bill 2279. Our purpose today is to explain why we have concerns about 4 of the 7 proposed regulations, proposed temporary regulations. And as to the 3 that we are not opposed to, we have no problem with those advancing. The regulations that I want to speak to you about today, about which we do have concerns, are KAR 60-11-101, 60-11-104, 60-11-105, and 60-11-107. And we are requesting this board to not approve those proposed temporary regulations, and at the very least, to delay those proposed temporary regulations. The reason and the basis for requesting that is those proposed temporary regulations are in conflict with existing Kansas law. They are also beyond the scope and not what was authorized by House Bill 2279. Additionally, to the extent they could be interpreted as expanding the scope of practice for APRNs, state agency action is not the appropriate body to accomplish that. It is a question for the legislature. And then finally, the standard for which temporary proposed regulations must be looked at against, as articulated in KSA 77-422, is not met. That there's no need to authorize these 4 regulations that I specified on a temporary basis that would justify bypassing notice, hearing, and publication requirements for permanent regulations. Nor is the standard for public safety met as to those 4 regulations. So if you would permit, I'd like to explain the rationale for the request, and I will be considerate of your time. But I think it is very helpful to just do a brief dive into the statutory construct in Kansas that clarifies what is the practice of nursing, and particularly including APRNs, as distinct from the practice of medicine. And look at what the Kansas statutes, even with the change in 2279, permit, and how that relationship is governed. So when we look at the Nurse Practice Act, because that's the best place to start, about what are APRNs and what is their scope of practice, those statutes clearly define APRNs. And those statutes, and particularly KSA 65-1113, state that an APRN is a professional nurse who is functioning in an advanced role. That act, which was not amended by the legislature, goes on to describe what a nursing diagnosis is. And a nursing diagnosis, by the very express terms of the Nurse Practice Act, is distinct from a medical diagnosis. And if I could read a portion of KSA 65-1113, which was not changed by House Bill 2279, it states that diagnoses in terms of the nursing context is the execution and management of the nursing regimen, and I quote, shall be construed as distinct from a medical diagnosis. If we move on in the Nurse Practice Act, again, not changed by House Bill 2279, the practice of nursing and treatment of nursing means the performance of therapeutic measures essential to effective execution and management of the nursing regimen and any prescribed medical regimen. So the Nurse Practice Act is really clear that the scope of practice for nursing, including APRNs, is in the lane of nursing. And that's distinct from the practice of medicine and surgery. And medicine and surgery is what is practiced by physicians and authorized only by law to licensed physicians. So if we move then over to the Board of Healing Arts Act, the Healing Arts Act, that's what defines who can practice medicine and surgery. And physicians who are licensed by the Board of Healing Arts can practice medicine and surgery. Physicians can also delegate acts that constitute medicine and surgery to others who are not licensed by the Board of Healing Arts, but they have to do it pursuant to the delegation laws in the Healing Arts Act, including 65-28-127. So that is our statutory construct, which was not changed except for one piece regarding written prescribing protocols. That's the construct within which we are operating. So I'd like to really focus in on what was changed in terms of the relationship between physicians and the important role that APRNs fulfill as part of the healthcare team in caring for Kansans. And I want to focus in on what actually was changed by 2279 regarding that relationship and regarding what was authorized. When you look,
I'm going to ask you to be very brief.
okay, this won't take long. I'm more than halfway through. So when you look at 2279, the only change it made was regarding the elimination of written prescribing protocols for APRNs. They don't need written prescribing protocols with a physician anymore. That's it. You will not see in 2279 a reference to collaborative agreements or eliminating the delegation requirements that exist in Kansas law. You won't see it. And so that is one of the very basic statements I'm making to you as to why the proposed regulations that I mentioned in the beginning, those four, can't move forward. That they conflict with the Nurse Practice Act, they conflict with the Board of Healing Arts Act, and they are not necessary on a temporary basis to implement 2279. And in fact, 65-11-104 which the senator referenced early, adequately addresses what was authorized by 2279. So we don't need these other proposed regulations. And in concluding my remarks, I will just point out to you, in the four regulations that I mentioned, they authorized APRNs to independently make medical decisions. And as I mentioned, only physicians can make medical decisions or delegate them pursuant to law. So this piece of the regulation, for example, in 60-11-101, that expressly authorizes independent medical decisions is not okay. And then if you move over to 104, 105, and 107, they suffer a similar infirmity because they allow APRNs, if it were passed, to independently develop and manage medical plans of care. But their scope of practice is limited to developing and managing nursing regimens for patients. So I will conclude by saying that for those reasons, I would urge you to deny adoptions of the four regulations I outlined in the beginning because they go beyond 2279 and they could be construed as authorizing APRNs to practice medicine and surgery, and that is in direct conflict with the law. So I will stand for questions.
Thank you. Are there any questions either for Ms. Colombo or Ms. Wahlberg?
Yes, Madam Chair.
Go ahead, Senator.
Thank you. So just curious, were these concerns brought forward during the original hearing?
I think Ms. Colombo is going to answer that question.
Good morning, Senator Faustido. That's a very good question. And I think the best way I can summarize it is to say, certainly the distinction between the practice of nursing and the practice of medicine was at the crux of a lot of the conversation around House Bill 2279. But that's the purview of the legislature, and the bill has passed. And what was decided by the legislature was to eliminate the written prescribing protocol. So that is the law, and the regulations that need to be adopted to go forward to allow for that, as the legislature approved. We're not in any way opposing or asking for delay on. Simply the regulations that go beyond what was established by House Bill 2279. And I guess the clarifying statement I would say is we couldn't, of course, address regulations that hadn't been developed, but our expectation was certainly that the regulations would not go beyond the law.
Thank you, Madam Chair, if I may follow up.
Certainly.
So, and I'm sorry, I didn't catch the, uh, beautiful young lady in the, yellow's name, but,
Miss Wahlberg.
okay, thank you. Um, so, um, so allowing those nurses to make those decisions, didn't the legislation, allow for, that they would have somewhat of a pre-approval from that physician? Can you clarify?
Yes,
Yeah,
I think you are absolutely right that the laws as they exist today and the laws as will exist after July 1st when 2279 becomes law absolutely require physician direction, supervision, delegation to the extent that APRNs will engage in acts that constitute medicine and surgery, i.e., execute, develop, and manage medical plans of care for patients. So I hope that answers your question.
Let me jump in and clarify if I might. The only area where that would not be true, looking at House Bill 2279, is on prescribing, because it did not change any other part of the nursing or medical regimen. So under House Bill 2279, there is independent prescribing, but the rest of the law on nursing practice and medical practice was unchanged.
okay, and thank you, Ms. Colombo. That's the clarification I needed. Thank you.
All right, thank you. I'm sorry, I misapprehended the question.
Senator Warren.
Thank you, Madam Chair, and thank you for being here today. I have a couple of questions for clarification to make sure I'm understanding what your position is regarding whether the proposed regulations in 101, 104, 105, and 107 go beyond the scope of the law that the legislature passed. So in, for example, 60-11-101, is the infirmity in the proposed temporary regulation according to KMS primarily in currently subsection A, when about 5 lines down, it talks about, well, the 4th line down, each APRN shall be authorized to make independent decisions about advanced practice, nursing needs of family, patients, and clients, and medical decisions. Is it the words "and medical decisions" that gives the KMS pause about adopting these temporary regs?
That is exactly right, Senator.
Okay, and is it that same infirmity that includes "and medical decisions" in 60-11-104 when it says, hold on, I'm scrolling to that. In 104, when it says in subsection B, develop and manage the medical plan of care. It's that develop and manage the medical plan, not the nursing plan, which gives KMS pause, right?
Exactly, Senator.
Okay, and in 105, it's again that same language in subsection B of 105, develop and manage the medical plan of care. And it's because in 104 and 105, subsection B strikes based on the authorization for collaborative practice. So in 104 and 105 and in 101, it was permissive for the APRN to develop and manage the medical plan of care for patients or clients because it was based on the collaboration with the physician who was authorized to practice medicine. Am I correct?
You are spot on.
And in 107, the infirmity that KMS sees is the same, subsection B, that same language and the same striking of based on the authorization for collaborative practice and the develop and manage the medical plan of care. And it's that medical part in each of the 4 regs that KMS is asking the board to not approve the temporary regulations. That's the issue, right? That it's medical plan and not the nursing plan. Am I correct?
That's correct.
So has KMS been in discussion with the Board of Nursing to address this before we got to here today?
Thank you, Senator Warren. Again, Rochelle Colombo, KMS Executive Director. The meetings where these regs were discussed were not meetings we were invited to participate in. So the regulations only became public to where we could view them on June 20th, so 10 days ago. They had already been submitted for this process by the time we were able to even review them, which is why we did ask at the earliest possible juncture, which is today, to be able to make you all aware of this, because again, we know the law needs to go forward and be implemented, but do have concerns about those, which you very succinctly explained, we believe go beyond because of that term medical.
Right, because it is the will of the legislature and the state that these go forward. We just need to make sure that they go forward properly.
Correct.
And has KMS in the last 10 days proposed changes to this to the Board of Nursing, or has that not been enough time to get together? I know there's been a weekend or so in there, but.
Well, my understanding is this is the process to do that.
Oh, okay. It's
We're going through the appropriate channels as we know them.
Okay, great. Okay, so we don't have any other proposed language or amendments to look at on this at this time. All right, thank you. Oh, go ahead.
I suppose the only
if I may, Madam Chair.
that may be of note is that I know that the Kansas Board of Healing Arts did request an Attorney General's opinion on the scope of House Bill 2279 on, I believe, June 10th. So before these regulations were made public, in an attempt to make sure that, you know, we were all on, I think, in the same page or moving towards the implementation, as that is the will of the legislature, but I don't believe an opinion has been made at this time.
That was going to be my next question. Has the Office of Attorney General weighed in on this? And we do see the stamp at the bottom from the Attorney General's office, June 9th, 2022.
The Attorney General's office has approved the temporary regs at this point, but we also have received an opinion request that is under review. So we have not weighed into the statutory interpretation as presented by the Board of Healing Arts in an opinion request.
So that's still an outstanding issue that
it is.
We don't yet have a determination on. Thank you.
Are there any further questions?
Madam Chair, this is Mary Greb Hall with a question, please.
Yes, go ahead, Mary.
Thank you, Madam Chair. This is for the Kansas Medical Society folks. You've mentioned that you were aware of these regulations 10 days ago. Was that correct?
That is correct. I believe that's when they were made public.
I was curious then why the board has just received, with your letter dated yesterday, June the 29th, your opponent testimony just the day before our meeting today, what the delay is until right before the meeting. I was just wanting to understand the reason for that delay and getting sort of 11th hour opponent testimony.
Well, I would defer, and if we have been incorrect, then I would defer. We I think got the public notice of the meeting a few days ago. I'd have to look. I think it was 2 days ago, and we called and asked if we would be allowed to submit testimony, and submitted. Let's see here. The notice went out on June 24th, and we reached out to the chair to ask if we were allowed to submit testimony. And when told that we were, we asked what the deadline was for that. So not an attempt to in any way delay or slow down the process, truly just to go through what we understood to be allowed by the process.
Thank you.
Are there any further questions?
Yes, Madam Chair, I have one.
Go ahead, Senator.
Thank you. So if staff could clarify, so the 10 days, are those all business days or were there weekend days included?
I am not sure of the timeline. I'm looking at Laura for this. What I will say is that Ms. Colombo was correct in that when she received the notice, she did reach out to me as chair and ask for the timeline, and I put her directly in contact with staff at the Secretary of State's office, and we set a deadline of 4:00 yesterday for testimony. So we did receive the testimony in a timely manner based on the information given to KMS.
Madam Chair, and then for staff, or you may know, so with what we're being asked to do or charged with doing now, does it override what the legislature has done, or, I mean, what role can we, play that does not override what the legislature has done, if that makes sense? Thank you.
What I can state is that this board is to hear proposed temporary regulations that go into effect immediately. There are standards for that are set out in statute we have to find, and the agency has to find, that the preservation of the public peace, health, safety, or welfare necessitates or makes desirable these regulations going into effect before the normal publication and public comment that a normal regulatory process is. So this board is to determine whether or not it is important that these regulations meet that threshold and should be put into place immediately ahead of the publication for the general public, which then the permanent regulations are to follow. And I believe Ms. Moreland indicated that that public hearing has been set and that process is in place, which would then give the public and anybody else an opportunity to comment. So the role of this board is to determine whether there is a need for temporary regulations at this point.
And sorry to belabor, Madam Chair, though, so our choices are to approve, or to make recommendation to approve or not approve, or is there another option?
Our options would be to approve the temporary regulations. We can do that individually by regulation because they each are their own separate regulation. So we can either approve any or all of them, or we could deny, or we could take no action on any or all of them at this point. Any that are approved today would go into effect immediately. And with that,
Thank you.
would ask is there a question, Senator Warren?
Yes, thank you, Madam Chair. And if the board recommends not approving some or all of the regulations, what's the process then?
Those would just continue along the normal regulatory process for permanent regulations, which would go through the publication today, the public comment period, the public comment session, the presentation to JCAR, and ultimate adoption. So it would be just like any other regulation.
And if some or all of these regulations aren't approved today, then we're at the status quo, except we have Senate substitute for House Bill 2279 becoming in effect tomorrow, and the rules and regulations to be adopted through the normal procedure for any temporary regulations that aren't approved today.
For any regulation that's not approved, yes. So
any regulation or temporary regulations, because the ones that we're looking at from the Board of Nursing are temporary.
They are just the temporaries, which would go into effect and be in effect 90 days, if I'm correct. Is that, I'm looking at somebody to make sure 90 days is accurate. I'm sorry. Temporary regulations are in effect for 120 days. Sorry. To allow that, the permanent process to continue. So with that, I would ask what the will of the committee is. Oh,
Madam
yes.
Chair, I have a question for Kara Moreland, please.
Certainly. Ms. Moreland, if you would come back to the podium.
Kara Moreland, are you there?
I'm here.
Just phoning in. Thank you. This is Mary Grave Hall for the Secretary of Administration. Good morning to you.
Good morning.
Given all the discussion and the kind of the last minute testimony we've received and all, and some of the objections that have been raised, I just was wondering from a practical matter, what would be your assessment if only 3 of these 7 temporary regs, that is the 3 that the KMS did not find objectionable, what would be the practical effect if only 3 of those 7 regs were approved as temporaries today? Thank you.
Sure, that's what I was back there thinking about. So thank you for bringing that up. We have about 6,800 licensed advanced practice nurses that are of the understanding, based on the interpretation we were given, again, from our legal counsel, that starting tomorrow, they will not need collaborative agreement, okay, for their practice. It's going to be very difficult to get that out to all of them. And I mean, there's only so much communication we can do in one day. You know, we can do the best we could, but it's going to cause a lot of confusion, which in my opinion is not going to help public protection. And you might as well staff somebody 24 hours a day on our phones, because they will be very upset, they will be very confused, and I certainly understand why.
Thank you very much.
At this point, I am looking for the will of the committee or the board.
This is Mary Greb Hall with a motion to approve all 7 regulations and temporary regulations at this time. Thank you.
We have a motion to approve all of the regulations as temporary. Do I hear a second?
Madam, oh, sorry.
Oh. Do I hear a second?
That
I have a motion from Mary Greb Hall and a second from Representative Wassinger. Any discussion?
Yes, Madam Chair.
Yes, Senator Falscadeau. Sorry.
Thank you. So again, I think I heard that if we do approve, it allows the process to continue. I think there was another public hearing opportunity. Is that correct?
My understanding is if we approve all of the regulations, they go into effect immediately. And based on the regulations, it would negate the need for collaborative agreements for all of the types of practice that are included in the regulations. And that would go into effect immediately for the next 120 days.
Mm-hmm. Okay, so I mean, it's just a lot of new information, and not it almost sounds like a hearing as opposed to just what we normally do on this committee. Well, okay, thank you.
Senator Warren.
Thank you, Madam Chair. As with any enactment of the legislature, we want to make sure that it is duly enacted and that we're clear on any rules and regulations that help implement the law as enacted by the agency charged with making rules and regulations. We heard that the Board of Nursing and the Board of Healing Arts have very distinct lanes that they operate in providing health care and for the health of Kansans. And it's important that we maintain that distinction. I am concerned with the change in the language as proposed in 60-11-101, 104, 105, and 107 that we are based on the language that's presented, we are expanding the scope of what in 60-11-101 is defined as each advanced practice registered nurse, as defined in KSA 65-1113, and amendments thereto can do. Because in 60-11-101, we see that in the proposed temporary reg, if it were to be approved today for 120 days, it would provide that each APRN shall be authorized to make independent decisions about advanced practice nursing needs of families, patients, and clients, and medical decisions. And it's clearly written there in 60-11-101 and medical decisions. Perhaps if we are later approving different regulations, that would be changed to and nursing decisions. And I understand that when it says and medical decisions, that has a distinct definition in law pursuant to the Board of Nursing and the Board of Healing Arts. So while we move forward to enact the will of the legislature and the state of Kansas in Senate Substitute for House Bill 2279, we have to be mindful that our rules and regulations don't overstep the bounds of what has been authorized by law. We are still waiting the opinion of the Attorney General on the issue of whether this proposed temporary regulations 60-11-101, as well as 104, 105, and 107 exceed the scope of what the legislature was looking at in 2279. So I would prefer that without the approval of the 4 regulations that gave KMS pause today, it would be status quo. And if I'm correct in that, because we wouldn't be adopting these 4 of the 7, if that's the will of the body. And if we do adopt them, then we have 120 days where possibly we have advanced practice registered nurses practicing medicine beyond the scope of their nursing license for 120 days. And then you get into all kinds of, well, what's the standard of care? Legally, there's a definition of standard of care. And what does that do, again, for the health and welfare of our Kansas patients for the next 120 days? So, that's where my concern lies, in the health and safety of our Kansas patients for the next 120 days, and also that we don't have rules and regs that go beyond the scope of the law and the policy as set forth by the legislature. So I'm uncomfortable at this date, at this time, advancing all of the 7 regs before us today. Thank you for allowing me to comment.
Senator Warren, was that a substitute motion?
Sure.
Or just a discussion? I couldn't tell. I'm sorry.
I would say while we seek to implement House Senate Substitute for House Bill 2279, it's important that we be confident that we are enacting the will of the legislature and the elected representatives of Kansans. And
thank you.
Yeah, just some discussion. Thank you.
Any further discussion? Hearing none.
I have a quick question. I'm sorry.
Senator Wassinger. Representative Wassinger. I'm sorry. I was looking at Senator Warren.
That's right. Well, I'm addressing my comment to Senator Warren. So would you be more amenable to passing the first 3 and working on the last 4? And how does that affect the nurse practitioners that will have this ability as of tomorrow?
Thank you, Madam Chair, and thank you for the question. If we could get some clarification, if we don't approve those 4 and we do approve the other 3, It's the normal process that we go through the normal rules and regs process making, and I'm just not confident that it's necessary for the rush, but maybe we could hear from the Board of Nursing. We did hear a little bit that, well, we'll have to explain to our members, but I think that's a smaller step than having, at least 120 days of the practice of medicine by those who aren't licensed to do so would be a difficult problem. And it doesn't change. If we could hear from the Board of Nursing, I don't think it would change. They don't have to practice, or excuse me, they can practice without the collaborative practice agreement starting tomorrow, July 1st, 2022, even if we don't adopt 101, 104, 105, and 107 today. Is that your understanding from the Board of Nursing?
Go ahead, Ms. Moreland.
I'm that is our understanding, but I'm a little confused, I will tell you, by all of this, and I apologize for the late date. However, I have no control over how long some of these may sit waiting for review. Because I started on these, I think the bill was signed on a Friday afternoon, and I started talking to our general counsel on Monday. So I apologize for the late notice. I was just made aware of their testimony 5 minutes before I came here. So if I'm trying to understand what you're asking is, if you don't adopt those 4 regs, can they still go ahead and practice without a collaborative agreement because of Senate sub for House Bill 2279? Is that what you're asking?
Yes, and I think I've answered the question if we look at 60-11-104A, because 104A does strike in subsection A each written protocol that an advanced practice registered nurse is to follow when prescribing. It strikes that, and it says then any advanced practice registered nurse may perform the following. And so in my reading of the 7 regulations before us today, if we don't approve the 4 that KMS was having concerns with, but we nonetheless do the other 3, which includes 104A, then that takes care of the concern from the Board of Nursing that our APRNs are ready to practice tomorrow, July 1st, 2022, without the collaborative practice agreement, because we will be approving as the board, if that's the will of the body, 104A. And that will go into effect tomorrow. So I think with 104A, it takes care of the problem that our APRNs can practice tomorrow, July 1st, 2022, without a collaborative practice agreement.
Related to prescribing.
Yes, related to prescribing.
Okay, so the only thing that they could do, if I'm hearing correctly, is prescribe without a collaborative agreement. All the rest of their practice would have to be with a collaborative agreement, because that's, is that what I'm hearing? I'm sorry.
And I'm not
a little
offering it. I'm
confused.
not offering any opinion. It's just some thoughts and discussion. And, I think with the nature and the complexity of what we're looking at, perhaps it's better to wait till we get the Attorney General opinion.
So we have a motion and a second on the floor to approve all 7 of the regulations. Any further discussion?
I have one question. If this just allows them prescribing authority, then legislative intent is not being followed. Legislative intent was to allow them to operate without a collaborative agreement. So unless that is part of what we're going to pass today, I have a problem with that, because I know what legislative intent was.
I believe that we have heard today some testimony on both sides as to whether or not these other collaborative agreements were included in the statute, and that is what the question is, I believe. Senator Warren.
Thank you, Madam Chair. The bill does say that in Section 5 that we were talking earlier, this act shall take effect and be enforced from and after its publication in the statute book. So it is the will of the legislature that that be so. And when we're looking at what the scope is going to be, and we have the regulations in front of us like we do today, that's a different matter, and it could possibly be making a policy decision that wasn't in, again, I'm looking through the bill, wasn't in the bill to provide that APRNs shall be making medical decisions, that it shall be remaining under the Board of Nursing, not under the Board of Healing and Surgery, and that with the regulations as proposed, those 4 that KMS was looking at in particular, that we possibly could be beyond the scope of the law and have some policy making in the proposed regulations. And that's my concern. And that's why I won't be supportive of the motion to adopt all 7 that's before us.
Any further discussion? Hearing none. I wish I could see everybody, but I don't know if that is possible. Okay. Hearing none, all in favor of the motion to adopt all 7 signify by saying aye.
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 Any opposed? Motion fails. Do I have any other motions? Are we ready to move on to the next set of temporary regulations?
This is Mary Greb Hall with an alternate motion, please.
Okay, go ahead.
I would then make a motion, maybe if we could consider each regulation separately and vote on each regulation of the 7 separately rather than as a group of 7.
That would be 7 separate motions, which is fine. But we would need a motion, a second on each individually.
I'd second her motion.
I think that was I don't know that I can accept a motion to vote on each separately. I think I can just accept a motion on each individually. Senator Warren.
Thank you, Madam Chair. I just want to clarify that may help the board here. I am also chairman of the Joint Committee on Administrative Rules and Regulations, and we do have an agenda for that joint committee on July 18th for our meeting that day, where these regulations will be under consideration, and that's July 18th. So that's a date certain. It's about 2.5 weeks from now. If that gives the board any insight into, well, when's the next time we'll be looking at these in the process. And that's only if these don't, actually that's whether these get approved today or not, right?
That's correct. These regulations will all be in front of the Joint Committee on Administrative Rules and Regulations at whatever date you calendar that.
And I think that's calendared for the agenda on July 18th. So just for the board's information.
Madam Chair, I have a question, a follow-up question for Kara Moreland, please.
Certainly.
Thank you. Ms. Moreland?
Yes.
Would it be practically, since the motion has failed to approve all 7 as temps or vote on that, is the second best at this point today, and given the timely manner you have commendably proceeded with your perms through the longer hearing process, would it be a workable and practical and desirable second outcome to just consider each of these regs separately, and perhaps that 3 of the 7 temps possibly might be approved today rather than none of them? And I defer to your expert opinion on that. Thank you.
I would say 3 is better than none. It's going to be very difficult by tomorrow to get all of this total change out. But if they could at least prescribe, since that's what the bill says, and the license renewal and the 60-11-103 that has to do with the licensure. I mean, that's language directly out of the bill. It's up. I guess I just would like a little clarification when I leave here today, because I guess my question, if the temps don't pass, then why are we taking the perms to JCAR for the very same thing? That's just my question.
I would say that the State Rules and Regulations Board and JCAR serve different purposes, and the State Rules and Regulations Board is to determine whether or not a regulation should go into effect without the process, whereas JCAR is part of the process. So I would, as chair, say that those are 2 separate and distinct processes with distinct purposes. One is immediate, one is following notice and opportunity. Senator Warren.
Thank you, Madam Chair. It's probably not possible, but do we have a timeline for when we might get an opinion about the scope of these regulations and the scope of the act, and when that might come out?
I do not have a time.
I was going to say, I know you probably don't have one, but
I apologize. But what I can say is that this is being looked at, the scope of the statute as well as the regulations.
Great, thank you.
Well, in Carol's defense, I know that they've been waiting to do this.
Mm-hmm.
So if I understand correctly with the communication I had with just now with Rochelle Colombo, and she can come up and speak to it, to go ahead and make a motion to pass the regulation 104 and 104A so that they can continue in their practice and do prescribing while we fix the rest in its verbiage where it's out of statute, apparently.
I believe that Ms. Colombo and Ms. Wahlberg were indicating that 104A, 103, and 113 are not objectionable to them and not and pursuant to statute. It was the others. So 104A, 103, and 113.
And I would amend my motion to pass those today so that they can go forward with at least the beginning of their APRN duties without collaborative agreements.
I have a motion to move those 3 as temporary. Do I have a second?
I'll second. Mary Greb Hall.
Mary Greb Hall seconds. Any discussion? Hearing none, all in favor signify by saying aye.
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 I think that I heard Faust, Godot, Wassinger, and Warren. Is that correct?
Parker's
And Mary
aye.
Greb Hall.
And Mary Greb Hall. And Clay, did I hear you?
Yes.
And chair
Aye.
votes aye. Motion carries. Hearing nothing else from the board, I would move on to the next item on our agenda, the Secretary of State proposed temporary rules and regulations. Clay Barker.
Thank you, Madam Chair. I'm Clay Barker, the General Counsel for the Kansas Secretary of State, and I will be testifying briefly on our temporary regulations for notaries public in Kansas. And a little background, in 2021, a little more than a year ago, the legislature adopted the revised Uniform Law Notarial Acts. It replaced the old statutes that had been around since the 1980s. It updated a variety of provisions. It made notary journals mandatory. And most important, it now authorized remote online notarization. That's where the signor and the notary are not co-located physically, but it's done online, kind of the way a Zoom or a WebEx meeting is done, with a lot of security provisions put in. There were 31 statutes in that bill, and one statute in particular required the Secretary of State to put regulations out on at least 11 different areas, specific direction. And we came up with, I believe it's 18 new regulations and removed 6 old ones. And these regulations just gave detail. They flushed out the mandates of the statute. And it covers a broad variety of issues. I listed them all. If you have questions on any specific ones, I'm happy to discuss it. The reason we need temporary regulations, it's somewhat of a timing issue. The original bill had this act going into effect on January 1, 2023. And in the legislative process, that was advanced to January 1, 2022. And we simply didn't have the bandwidth to get all the software and IT infrastructure in place by then and get the regulations out. And so the law has been in effect for about 6 months now. I've gone around the state making presentations to notaries and lawyers about how it works. And a lot of them have been working just off the law, but now we really need these regulations now that they've been approved. And it was a very worthwhile, detailed process. Took a little longer than I thought, and we need these regulations out as fast as we can, so the details are out there for everyone to implement. Some recorders of deeds are accepting online documents right now, and others are waiting for the regulations. So I believe it does meet the public welfare need of the statute for a temporary reg. And we have the hearing for the permanent reg also set on September 6th. Sounds like a busy day for hearings to put the permanent regs in effect, which would be identical to these temporary regs. And Madam Chair, if anyone has any questions on the process or any of the specific regulations, I'd be happy to discuss it.
Are there any questions?
I have a question.
Yes, Senator Fasquedo.
Thank you, Madam Chair. So, Clay, good morning. Would you please clarify again the main reason for the notary, and is it just for convenience? Is it to just expedite, just to explain the main reason and who is, and just the process real briefly?
Senator, I wasn't quite clear on the.
So, okay, let me ask it this way. So the notary is notarizing what?
Well, there's a definition in the statute about what a notarial act is. So a notary can verify a signature that I sign my name, but they look at my ID to make sure I really am Clay Barker, and they notarize it. They verify that. They can give oaths. They can do a variety of functions, and it's that certificate at the end of a document, and it's legally to give extra assurance that the signature on the document is legitimate.
So, Madam Chair, Clay, I understand that process. I know what a notary is. So I'm just I want you to specifically say what this, you said you took out old regs and we implemented 8 more or 16 or 8 more. And in this instance, you said you've been traveling the state, explaining to people how to do this. So what are they doing, and exactly why is it so important to approve these temporary rules? Maybe I missed something earlier, just clarification on what the main need is. Thank you.
All right, Senator. Well, a large group of stakeholders, Kansas Bar Association, bankers, title companies, real estate, pushed for the bill to get through the legislature in 2021, and that made a lot of changes to the notary laws. Some were just expansions or clarifications. Others were more significant, especially the remote notarization. These regulations fill in the details about how notaries are supposed to comply with the law. And that's why we need these out as temporary regs as soon as we can, so those details are out there, because the law is already in effect.
Right. Okay, that's what my question. So the remote part of it is where you're really pushing and going now, and exactly how does that part work? And then I'm good, Madam Chair. Thank you.
All right, well, the remote notarization, a notary gets permission to do remote notarization through our office, and that requires them to get training, which is free, that's provided by our office. Then they have to hire usually a commercial third-party group that has all the security, which is also listed in the statute and regulations, that the notary can work through. And this again just provides some detail on how to do that. The third-party groups have to also register with our office, and we have an approved list that notaries can look through. We don't recommend anyone, but we verify that those third-party providers meet all the basic security requirements, and then the notary can pick, or the notary's employer can pick which ones they'll use.
Okay, that totally answers my question. Thank you, Madam Chair.
Thank you, Senator. Are there any other questions?
And Madam Chair, if I could, we did pass these regulations. We worked with all the stakeholders we were aware of to give input on these. So it was a collaborative process, and I'm not aware of any group that has a problem with the regulations. I've learned over time that law enforcement has some issues with one provision in the statute, but that's beyond the scope of this board.
Okay. Senator Warren.
Thank you, Madam Chair. Thank you for your, I guess it's testimony in front of the board, Mr. Barker. Are these regulations, are they based on what other states who have authorized e-notarization? Are they kind of based on what's working elsewhere?
Thank you, Senator. Good question. Yes, we did check with other states about how they implemented, especially the remote notarization part, how much detail to put in the regulation versus being a little more general. And the Attorney General's office was very helpful in giving us guidance on that. And also Mary Greb at Department of Administration was a big help in getting these drafted correctly. So yes, we took input from stakeholders and other states' experiences. It is a uniform law, so the regulations in most states are very similar.
Are there any other questions?
Just a comment for Clay Barker, please.
Yes.
Clay, I wanted to thank you for the compliment. I know this has been quite a big project, and it spanned a couple of changes in personnel, I believe, over there, and a lot of drafts, and one of the certainly bigger projects we've seen with temporary regs involving also the revocations and the new ones. And so I commend you on your timely work on this, and it has been quite a project, and also on your timely notice of public hearing for September 6th, which should allow you then to get your perms in place before the temps, if the temps are approved today, of course, before those temps would expire. So again, kudos and thank you.
Are there any other? Oh, go ahead.
Oh, I should also probably thank Laura Murphy for helping out with a lot of patience on this. That's all you're here.
Hearing no other questions, what is the will of the board?
Make a motion to approve all the regs as temps.
We have a motion from Mary Grabhold. Do we have a second?
I'll second that. This is Barb Wassinger, sorry.
Thank you, Representative Wassinger. We have a motion and a second. Any discussion? I just have a question for IT. Is Senator Billinger on still? I just want to, so we have the votes or we know who's
I'm
here.
still on, but I don't know if you can hear me.
Okay, I wasn't sure if you were still on. Okay, we have a motion and a second. All in favor signify by saying aye.
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 Any opposed? Motion carries. Thank you. Next on the agenda are, Senator Warren was an aye on that. Next on the agenda, other matters. I don't know of anything else to come before the board today. I don't hear anybody bringing anything else. I spoke with Laura before we started. There are some other temporary regs in process, but they are not yet ready. So I am not sure when our next meeting will be. We will reach out and kind of follow our normal procedure of suggesting a few dates and seeing what works for everyone. Hearing nothing else to come before the board, Happy New Year to all of you, and thank you for being here. Meeting adjourned.